Good morning, Liberty. It is Monday morning, December 17th, 2018. My name is Michael Boldin, 9:30 a.m. Pacific time here on the West Coast, broadcasting to you live through YouTube, our channel at the 10th Amendment Center, youtube.com/10th Amendment Center. And of course, I really appreciate you joining me here this morning to kick off the week. And good morning to you, or good afternoon, good evening, or if you're watching it live or in the archives, it doesn't matter to me how you get a hold of us or how you're participating. I really appreciate you joining in. I hope everyone had a really good weekend. We sent out a couple of emails. We generally don't send out them back to back, especially over the weekend like this, but there were two big anniversary days over the weekend. First of all, December 15th, as I did my show on last week, Friday, was the anniversary of Bill of Rights Day, and I wanted to talk a little bit about the foundation of the Bill of Rights and the entire experience, the American experience and the Constitution. Thomas Jefferson, as I mentioned in last week Friday's show, called the 10th Amendment the foundation, but he wasn't the only one. So many of the other states, led by people like John Hancock and Samuel Adams in the Massachusetts Ratifying Convention, they weren't even going to ratify the Constitution if they did not have an amendment promised to them that would basically become the 10th Amendment. So this was a big deal. And we sent out an email about that, talked about it on last week's show. And then, of course, also on Sunday, yesterday was December 16th, which was the anniversary of the Boston Tea Party. And we published a great article from Dave Benner. He's an awesome historian. He does a lot of stuff on social media. We're running a lot of his videos over on our BitChute and Brighteon channels. And we also publish him a little bit on Minds.com. He does all these little 3 to 4 minute, sometimes 5 or 6 minutes, basically short snippets about specific issues, either in American history or Revolutionary period or constitutional issues, founders, etc., etc. He wrote a great article about the Boston Tea Party, basically the hidden history of it. Everybody wants to say that it's just about tea, but Dave points out that it was much broader than that. It was about this unlimited power of a far-off government to be able to tell a local people what they can and cannot do. So it was, again, this idea of being opposed to a one-size-fits-all centralized solution. That was really the impetus for the Boston Tea Party. Now, today I don't want to necessarily talk about those. I just wanted to mention that. I also want to mention that next week, on next week's schedule, I'm going to be a little bit off. It's Christmas, so I'm going to take at least the day before off and not do a show on Monday. It's likely I will not do a show on Wednesday either. So you might just have one show, but I'll make sure to post an update on our channel on YouTube for those of you who like the live shows. I'll post an update on YouTube to let you guys know when the next broadcast is going to be. So even if it's like 5 days in advance, you'll get a notification. That way you can set a notification in your app or on your browser when you want to get the update. Of course, we're normally here outside of the holidays or when I travel for events every Monday, Wednesday, Friday at 9:30 a.m. Pacific time, and I really appreciate everyone who joins in. Today I want to talk about Obamacare because on Friday there was a big deal in the federal courts. It was a court down in Texas, a district court down in Texas that held the entirety of Obamacare is unconstitutional. I just want to go over a couple of the minor things, the kind of technical things that may be confusing to people or maybe that they're not reporting on. Of course, in general, what I hear about this Obamacare opinion, mind you, courts issue opinions or their decision on it, not rulings. They don't create law. But generally what I'm hearing is people on the left say, oh, this is a bad decision. People are going to be sick in the streets. And people on the right have been mostly mum, at least in the political sphere. But some people are definitely cheering it and thinking it's all done. But basically everybody's kind of wrong on what's actually happening. And there's some really good posts over at Reason.com. They publish a group that used to have their own blog that moved to the Washington Post of all places and then now over to Reason. It doesn't seem to really fit wherever they go. I always thought they were better at their own site, Volokh Conspiracy. It's a group of originalist style, mostly original style. There's a couple of ones there that I think are just NSA tools, like a guy named Oren Kerr, for example. But it's a group of legal scholars, people who are really good on understanding the whole precedent-based view of the Constitution, but they tend to kind of tie in an originalist kind of position on it. So it's really good technical analysis of day-to-day issues when you're interested in kind of the court watching, things that are happening on the court level. And before I get into that, I do want to, of course, mention if you are watching here live or if you're watching in the archives, whether it's on YouTube or Twitter or Facebook or Brighteon.com or BitChute or Keyport or wherever it is, or even if you're listening to the podcast, which is now on iTunes, Google Podcasts, and then also on Spotify, like us, give us a thumbs up, share it. Podcast, review us, give us a positive review, 5 stars all around, of course, because we're the best ever, right? And what that does is this is a grassroots effort here. We don't have tons of money. I broadcast, for those of you watching the video, you could see I'm broadcasting from a spare bedroom. I set it up as a studio, my home office, and a spare bedroom and studio here in downtown LA. So this is a grassroots effort. So the more that you like and share and comment and all that stuff, the more that it triggers algorithms on these various sites to tell them to show the links or the video or the audio to more people. So it does help spread the words. Our subscriber count is going up. Our view count is going up across the board. So that's very helpful. I want to thank everyone who does that. And of course, if you have ideas for shows, you can leave those in the live stream comments. Like we say hello to Joseph Standridge out there in the live comments. Or of course, you can also email me at team@10thamendmentcenter.com. team@10thamendmentcenter.com. I do see all those personally. I may not respond to them personally, but I do see them. So if you want to get some information over to me, feel free to email. So let's get into this first report that I want to talk about. This is from a scholar from South Texas, I believe, Josh Blackman. He's well known in his reporting and analysis of the various Obamacare cases over the years. He's written a couple of books on it. He's actually very consistent in his views, even where I disagree with him. And it's a fun article. It's linked in the show notes on YouTube, but we also post all of our archives and show notes over at 10thamendmentcenter.com/goodmorningliberty. Again, 10thamendmentcenter.com/goodmorningliberty. It's a fun article because he starts it out talking about how there's all these articles complaining about this opinion from the courts. And after a few paragraphs, he's like, oh, actually, I'm talking about a court case from back in 2011, Florida versus HHS. And now it's basically the same kind of alarmist responses. But in the most recent one, which was Friday, the 14th of December, Texas versus United States, the Northern District of Texas found that the Affordable Care Act is unconstitutional in its entirety. This wasn't just about the mandate. This was in its entirety. The opinion, he notes, has two main components. First, because the Tax Cuts and Jobs Act of 2017 reduced, and this is the one that I think most people who are watching this kind of expected. Oh, they reduced the penalty to 0, so then there's no more penalty, so you can't have a mandate. So everyone kind of expected that, but he went much broader. So first, because the Tax Cuts and Jobs Act of 2017 reduced the ACA's shared responsibility payment to 0, the mandate to purchase insurance could no longer be saved as a constitutional fundraising tax. So that was the whole argument. Of course, that's the Justice Roberts thing. It's a fundraising tax. Well, if there's zero tax being collected, then and no one has to pay it, then there is no more mandate. It can't even exist. Now, where he went broader than this, and I may just be a constitutional extremist, but I still think it's kind of weak, personally. But second, he struck down the rest of it. He found the rest of it was unconstitutional because it could not, here's how I put it, the remainder of the ACA could not stand without the, quote, essential mandate. In other words, the term that they're using in the legal world is severability. And this happens on all bills. When we monitor bills on a state level, it happens often in Missouri. A guy named Ron Calzone with Missouri First is very good about making sure that in his activism, legislation includes a severability clause. Basically, in legislation, they'll include something sometimes that says, hey, if anything is, ruled unconstitutional or illegal in this act, the remainder is severable. They can cut it off. In other words, you can cut off one piece and the remainder stays in effect. So they show that, okay, each piece is its own piece and its own separate thing. That's their view. Now, there is a debate over the severability of the Affordable Care Act. Some people want to say that if part of it is struck down, that the rest of it can remain. And other people say that, okay, if the mandate isn't there, and this Judge O'Connor, I think his name is, O'Connor, says, oh, okay, I'm looking at the history of this, and I'm looking back to 2010, and according to what I see in Congress, they said that the mandate was the essence of the federal act. And if you don't have the mandate, then the rest of the act just doesn't exist. You can't just have all these other regulations. And of course, the first thing I started seeing all over Twitter and blog posts and articles was this is an insane decision. No, you can't strike down an entire federal act. It's been around for so long. It's intertwined with everyone's lives. It's dangerous, etc., etc. And of course, that's the argument of fear. You can't turn around anything because once it's part of the fabric of the system, you can't get rid of it. And something is constitutional or unconstitutional whether or not it's part of the fabric of the system. I mean, unfortunately, things that are unconstitutional have become part of the fabric of the system, so there's less political will to get rid of it. And in the next article that I'm going to cover, there's a point about how it's unlikely that Congress will ever do anything about it. I just want to look over back to the live chat here on YouTube. Hi to Ward Lawrence, Joe Giltner, Awesome Woodsider, Matt Hughes, Steve Smith. Got 1 second to say hi. Catch you later on the podcast, which could use a few more reviews, guys. Hint, hint. So yeah, especially if you listen on iTunes. I only checked out on iTunes, and I've also listened to a few on Spotify. I don't like listening to myself too much. But I just wanted to check kind of the quality of the uploads and things like that. But if you hit like a 5-star review on iTunes, I reviewed myself. I guess I got to be honest about that. But it'll say, oh, we don't have enough reviews yet because it's pretty new there to actually show an overall rating. So if you're listening to the podcast, and I appreciate Steve for popping in to say hello live, and I also appreciate you listening to the podcast. I'm pretty excited to have those available. But make sure to review. Matthew Butts says, this is awesome. Obamacare is declared unconstitutional, now past Trump care. This is referring to a tweet. I'll get to that in a moment. And Woodsider notes that this is the same take on Trump's tweet as well. Hi to Logdon Boydell as well. I appreciate you being here and your support for our work. So this judge, O'Connor, is basically saying he's not taking the position that the rest of Obamacare, this is where I have an issue. He's not taking a position that the rest of Obamacare is unconstitutional because the federal government does not have the constitutional authority to do all these other regulations in Obamacare. I mean, that would be kind of a hardcore constitutionalist viewpoint. Someone who supports liberty. You don't want to centralize control over any marketplace. And the more regulations it is, the more it drives up costs and the less available and affordable it really is in the long run. And if you watch our 10th or Tuesday show, which we broadcast live once in a while through Facebook, the Evil Empire, Mike Meharry and I talked about his experience in signing up for the exchanges in Kentucky. And over a 2-year period, his premium for he and his wife, Cynthia, 2 self-employed people, went from like $600 to $1,300 a month. So insane. That is not affordable for anyone, really. I mean, it's affordable for rich people, but it's not affordable for all the rest of us. So this whole nonsense of being called affordable is really, really bad. So he didn't strike down, or he didn't say that the rest of it was unconstitutional because it's unconstitutional. He just said it's unconstitutional because Congress intended to have the mandate, and without the mandate, then the rest of it has to be redone. And that leaves things open to Mr. Trump. And I'm going to skip down past a couple of things. So Donald Trump tweeted last week, Friday evening, wow, but not surprisingly, Obamacare was just ruled unconstitutional by a highly respected judge in Texas. Great news for America. Now, if he just left it at that, then that's one step. But of course, he has to follow up with, or I guess the previous one was the previous tweet. He says, as I predicted all along, Obamacare has been struck down as an unconstitutional disaster. Now Congress must pass a strong law that provides great health care and protects pre-existing conditions. Mitch and Nancy get it done. So really, Trump and the Republicans, and actually now Trump and the Democrats are going to be partnering to give us Obamacare. Even though the mandate doesn't exist, a vast majority of Obamacare is still around. The worst part, it's onerous regulations, the things that really drive up costs. And Mike Meharry's personal example of having the costs at $1,300 a month is impossible for most human beings to deal with. We can't afford this kind of garbage, especially as the Federal Reserve is debasing the currency year in and year out, making it more and more expensive for everyone's life in every aspect of life, from food to housing and clothing, and all the basics are more and more expensive because we have more dollars through inflation chasing the same amount of stuff. So Trump is all on board with the political viewpoint that Obamacare was struck down. Now he wants Obamacare, but minus part of it. So here's going back to Blackman's post. So his constitutional analysis, Judge O'Connor, he says this is not really an audacious ruling, even though he actually says this analysis, he actually disagrees. He doesn't think it's severable. And that's all they really care about is whether it can be. This is the technical legal view analysis. Like all they care about is can you sever the rest of it? They're not really looking from an original constitutional viewpoint where the founders were very clear where things like agriculture and healthcare and all these personal choices were going to be reserved to the states of the people. James Madison summed it up in Federalist 45 when he said the powers delegated to the federal government are few and defined, and those reserved to the states and the people are numerous and indefinite. So most everything was going to be handled on a state-by-state basis. Now, that doesn't mean that the states are good or they're going to come out with some libertarian outcome. That just creates a scenario where you can have kind of competing viewpoints. And I think that when you have competition and the market exists, I really believe that liberty in the long run wins because people learn by example that they're going to get better service, lower prices, more choice when you have an open market. But when you have one-size-fits-all solutions, you don't. Now, again, when it comes to healthcare, you may have a situation in this federalist structure where Vermont and California go with a single-payer system, and then maybe Montana and Oklahoma go with a free market system, and maybe another state like Arizona comes up with a quasi one. I don't know, but the thing is people are going to learn much quicker what works and what doesn't if you have multiple versions in different geographic areas. And you also have a greater chance as an individual or as a group, people have greater chances of changing things to their liking in a smaller government, a smaller geographic area as well. So I don't like the fact that it's just a discussion about whether or not it's severable, because there really isn't a discussion about whether the thing should exist at all. They're mostly talking about technical challenges, but that's okay. We'll take it. So Judge O'Connor's ultimate conclusion, he writes, on severability, that the entire ACA must fall if the mandate is unconstitutional, was supported by the NFIB. That was the original Obamacare ruling, National Federation of Independent Business versus Sebelius, joint dissenters. So in other words, there were 5. It was 5-4. There were already 4 votes on the Supreme Court at that point that actually held this same view back in 2010, 2012, whatever it was. And his analysis about the mandate, saying that the mandate is unconstitutional if there is no penalty, this was already supported by the majority of the Supreme Court. So he's saying it's not really cut and dry. He's responding to a lot of other legal experts who say this guy's a joke. How could he ever strike the whole thing down? This is absurd. But this is a more measured kind of technical analysis from the law world saying, well, you know, the Supreme Court could go either way on this. We don't know. We don't know. But the problem is let's say the Supreme Court. Now, to back up one more thing, this did not stop Obamacare from being implemented. In fact, there's like an official Twitter account, maybe for HHS or something like that on a federal level, that said, look, open exchange for the Obamacare exchanges. There's a court case going. We're still accepting enrollment. Nothing's shut down. Some people think that this judge struck it down. It's over. It's done. I want to clarify that it is not. This was, in fact, there was no injunction, nothing whatsoever. It literally was just his position. It's going to be challenged in the next level, and it's setting up a controversy to drive it to the Supreme Court. One other viewpoint that I want to talk about here is another approach to say that Obamacare is unconstitutional. And this is from constitutional scholar Rob Natelson. He originally published this over, I think, at The Hill. Maybe it was Daily Caller, and we ran it here a couple of weeks ago on December the 5th. And basically, he's talking about the origination clause, saying, first of all, he says the penalty is gone, but the remainder of Obamacare still plagues us. Let's be clear. The problems with Obamacare aren't just about the mandate and the penalty. There is much more. And I know a lot of people only want to focus on the penalty and the mandate. I think that's where Trump comes from. He thinks Obamacare means mandate and penalty and everything else is fine. He's all for, having centralized control and regulations over everything else, which is really problematic. But Rob says there should be a challenge, and I'm not sure if this came up in this Texas case, but on the origination clause, saying that all bills for raising revenue shall originate in the House of Representatives. And Obamacare did not follow that process, is what he's saying. And he goes through a few points that I want to just go over quickly about the original meaning of the origination clause. He's one of the leading experts on this. He says only a representative, not a senator, may introduce a tax bill. Obamacare was a tax bill, supposedly, as Roberts told us. The bill must pass the House before going to the Senate. However, he says, the Senate is not bound to simply accept or reject. They may amend the tax bill before passing them. Then it has to go back to the House to be approved by the House. So if it has to start in the House, then goes to the Senate can change it, goes back to the House for approval. But the problem is that's not how it played out for Obamacare. He writes here, the Senate created Obamacare by seizing a minor revenue bill that had passed the House, stripping out its contents, inserting new taxes, which it did have the power to do, and adding some permanent appropriations and a Goldbergian regulatory scheme, which it had no power to do. A purported law passed in violation of the origination clause is void. So he believes that just because, again, this is a technical thing. No one's really talking about, does the federal government, even people who are on our side, are not saying, does the federal government have the power to even do all these regulatory schemes and the appropriations and all that? I would say, no, they do not have the power to do basically anything in there. Maybe it's a massive bill. I haven't read through the whole thing. You'd be stupid to read through that. It's like, I don't know. It's just insane that people are basically supposed to be on our side, and they're turning a blind eye to all the other stuff in there. And I want to go back to Blackman's article here as well. There was a section that was talking about the political dynamics. He basically says, he's comparing the previous case that he started this article out from 2011, 2012, and he's saying 2019 is very different. If the Supreme Court were to hold that the GI and CR provisions are unconstitutional, that's like the other parts, the major parts, I suspect Congress would reenact those provisions with broad bipartisan support. And he says and this is where I disagree with him. I agree that they will probably do this. Trump wants a lot of garbage, and so do the Republicans. And so even if the Supreme Court were to follow with this Texas opinion, we should expect Congress to come back at us with Republican-led support in the Senate and the Democrats in the House partnering with the socialist Donald Trump to give us basically Obamacare minus the penalty and mandate. He says, I suspect that Congress will reenact those provisions with broad bipartisan support. I agree. Here's where I don't. He says there is no constitutional problem with Congress enacting these standalone insurance reforms without the mandate. So this is just backing up this view. They're like, it's okay. They can do basically whatever they want, just no mandate. That's all the only problem that they have constitutionally. Now, indeed, to avoid any disruption, and we could see it play out like this, the Supreme Court could delay its ruling by a single tax year to give Congress a chance to act. Justice Alito floated this option during oral arguments in King versus Burwell. So it could play out like this if Donald Trump is the political master that I think he is, even though I disagree with so many of his views. I disagree with his principles and his approach to so many things under the Constitution. I think politically the man is a total master, better than anything we could even have imagined in modern times. He gets a lot of things to happen. And Could it be that he is seen as the hero of saving the pre-existing condition issue, of protecting all kinds of regulatory structures for national health care, but getting rid of the mandate? So he gets support of the people on the right who only care about the mandate and the penalty. And then he gets support from some people on the left who only care about the pre-existing condition thing. And he gets a Supreme Court ruling in his favor, and he looks like a winner, and then he wins re-election. It could play out like that. It's not positive for liberty or the Constitution, because all of this stuff should be struck down as unconstitutional. Ward Lawrence in the chat says, where in the Constitution does it say healthcare is a right? Absolutely. And Matt Hugh points out, dental is another $200 a month for us. That is crazy. $1,200 a month for my wife, son, and myself. We're only one step above the lowest grade plan. And I think that was Mike. He was looking at the silver plan. Hi to Larry Clark. We're talking about the Obamacare court case, that the decision that was handed down on Friday. You can actually rewind this, or it will be posted later on in the archives here on YouTube and elsewhere too. So the expenses are crazy. And I guess I basically have been answering states' rights gist question. What are the odds Obamacare dies and no replacement is added because no one in Congress can agree on a replacement? I think they all, or a vast majority of them, agree on some kind of replacement, especially as we're going to see the Nancy Pelosi team come in. That's where I think Trump is going to be the most dangerous, because he's going to use that bully pulpit, and he will be very friendly to getting a lot of bad stuff done while sounding positive on things like Obamacare is gone. Now let's do what we need to do, Mitch and Nancy, two of the worst human beings on the face of the earth. Now the thing is, we don't have to rely. My friend Joe Wolverton, who's written for the New American for a long time, he had a tweet recently, said, hey, we're basically relying on the goodness of a judge. This is a bad place. Like, it's positive that this judge in Texas said the whole thing is not severable and it's unconstitutional because of that. But when you're relying on that, you're in a bad place. So let's say the Supreme Court strikes it down and says, okay, Congress, we know you want to get through this, so we're not going to put an injunction across the country. We're going to give you a full year to work it out. Even though it's unconstitutional, we'll let it play out. And you guys work out a new thing, so it's a seamless transition. And so basically nothing will change on the ground for those of us who are getting hammered by the lack of choice and high costs. So Mike Meharry wrote a great article middle of last year, July of 2017, talking about how we shouldn't be relying on the federal government to limit itself, because you end up with situations like this, even in a place where maybe the Supreme Court says a huge regulatory program is unconstitutional. They create an environment where everyone else is going to create a replacement in time to have a seamless switch to a new one. And we shouldn't rely on that. We should take action to undermine, reject, and nullify it before it ever happens. I never signed up for my Obamacare mandated insurance, and that is my small part. I refuse to take it, and I refuse to pay the penalty. And I know they've got a column over at the IRS, probably racking up penalty charges for whatever that is for the couple of years that I refuse to do it, but I'm just not going to do it. I don't have a lot where they can come and collect, so I rent an apartment. So I'm in a place where I can probably do that. I can take that risk. I don't necessarily suggest that to everybody, but they do not have a legal backing to be able to collect. So Mike points out that the ACA, Obamacare, was predicated on state cooperation. The federal government never intended to run the healthcare system alone, and ultimately it can't do it without state help. And we know this because it even tried to compel states to expand Medicaid under the act, but that portion was struck down in the famous Obamacare case, NFIB versus Sebelius. So there are practical steps that states can take to undermine Obamacare or any Republican or Trump care replacement. I guess I got to stop saying just Republican, because now it's a split Congress and House. One step that Mike says is refuse to expand Medicaid. Unfortunately, the general population loves expanding Medicaid. In places where even the supposedly conservative people are in charge, like South Carolina, we see efforts to push forward expansion of Medicaid, Kansas, Idaho, and elsewhere. So Missouri, for example, we're seeing a lot of effort to expand this. But you can refuse to expand Medicaid, and you can also refuse, I think it's Medicare, actually. I should have added that properly. But and also refuse to set up an exchange. These are two important parts. Now, West Virginia, they got rid of the state-run exchange and said, federal government, you do it. We know the federal government is really bad at doing stuff. It doesn't have a lot of resources. It doesn't have the number of resources, and it relies on states to do things. So when enough states stop participating, I mean, they couldn't even run a website on their own. So the less that states do for them, the more likely it is to topple the program. But this is only a small part, and Mike notes that states can go even further. Judge Andrew Napolitano, he writes, noted that if a number of states were to refuse to participate with the ACA in wholesale fashion, that multi-state action would, quote, gut Obamacare. And here's how Napolitano put it. It will gut Obamacare because the federal government does not have the resources or the wherewithal to go into each of the individual states and basically run this healthcare system. So Mike notes that states can pass legislation to completely end any and all state participation in the Affordable Care Act. And we saw a really good, very simple bill that was introduced in all places in Connecticut. And I think legislators should introduce bills even where they know it's not going to pass, because it creates a kind of it's a rallying cry. It's an educational tool. And it lets people know that there is an option other than relying on Washington, D.C. to limit itself. And the bill that was introduced in Connecticut last year basically said this, quote, the general statutes be amended to repeal all statutes implementing healthcare mandates required under the Affordable Care Act, prohibit the state from participating in any program under or appropriating or expending any monies in furtherance of said act, and dissolve all programs related to said act. And now they're going to have to go beyond the Affordable Care Act because of the amendments, and then you're going to have to address whatever is going to be the replacement. Basically, we're not going to participate. If you're going to do this, and if enough states do this, the feds cannot make it happen. They do not have the resources. And one of the ways, and I've mentioned it briefly, is insurance commissioners. Insurance commissioners, Mike noted in his article, serve as the enforcement arm for insurance regulation in the states. The federal government has no enforcement arm. So the feds assume that the state insurance commissioners would enforce all the provisions of the ACA. So if there's a violation or a regulation issue by a business that is not providing the services mandated by the federal law or federal regulation, who do they call? They don't call HHS in Washington, D.C. They have to call the state insurance commissioner or the Department of Insurance. And if that department or commissioner is banned from doing any enforcement of the federal act, then there's no one to do the enforcement, and it creates a vacuum. So we want to see this happen over and over and over. I also was looking into, a couple of years ago, the idea of tax levies. The levies are generally done by the county. So if the county level, the registrar doesn't participate in that and people don't pay, there's other ways that you can be really creative to say, well, if the state doesn't participate, then it's going to be really problematic for the federal government to deal with this. But this whole article is linked in the show notes. We also have another piece that covers the 4 types of legislation and the model bills that you can download. Nullify Obamacare in 4 steps. It is linked in the show notes here on YouTube, and then it'll also be in our archives over at 10thamendmentcenter.com/Good Morning Liberty. I don't know if you can hear in the background, I mentioned last week on Friday's show that we've got a little construction below us, so I apologize if you're getting some drilling there, but hopefully it's not too bad. But that basically wraps up what I wanted to talk about today. I hope you found it interesting, insightful, educational. I appreciate... quick before I go, Dusty Cartenson, how does one refuse to pay the penalty? There's actually a line item where it calculates that. And I just don't include that in the amount that I pay. So you just don't do it. I know they're probably calculating the amount. And we actually did a video. I should link it. I'll try to go into the archives and link it. We did a video a couple of years ago talking about how in the law itself, it specifically bans the IRS from doing its normal collections activity for people on the mandate, the penalty tax, or whatever you want to call it, the fine. They don't actually have a way to go and collect it. It could be changed in the future, but if they totally get rid of it, maybe we'll get some relief out of this. So I've gone out of my way to not do that. I know it's risky, but for me, it's the right thing. So again, I appreciate everyone who joined me. Logden, Timothy, Ward, Larry, Dusty, Matthew Butts, Matt Hughes, Steve Smith, Woodsider, Joseph Standridge, everybody else. I really appreciate you spending some time with me again today. I hope you have a wonderful Monday. We're prepping up for Christmas next week. A reminder, I will definitely be off on Monday. I will probably take off on next week, Wednesday as well, but I will be here on the normal schedule, Monday, Wednesday, Friday this week. I expect, unless something comes up interesting, I expect to do a show on Wednesday about asset forfeiture, the federal equitable sharing program, and what states can do to undermine and opt out and nullify it. But we'll see how things play out. If you've got ideas of what you'd like me to talk about, make sure to leave some comments, whether it's here in the archives on the video, YouTube, Brighteon, BitChute, or elsewhere, or feel free to email team@10thamendmentcenter.com. And again, thank you so much for watching. Have a wonderful Monday, and we'll see you next time here on Good Morning Liberty. Have a great day.